Good morning, everyone, and thank you so very much for attending our webinar. The response has been absolutely excellent for this particular one, and we have two very well informed experts who are going to be discussing Bill 25, protecting our personal information and how it impacts on individuals, but we'll start with how it impacts on nonprofit organizations. As Brendan said, please keep your microphones muted so we have a professional product with the recording at the end. I do want to take a second, it's out of the ordinary, to announce that on December the 10th, our webinar is going to be on legal aid with a lawyer from the Point St. Charles and Little Burgundy Legal Aid Clinic. Now, some of the seniors who are on may say, well, that doesn't relate to me, but it could. And I also want you to spread the word to grandchildren who are maybe just starting out, adult children who may have need to have this information. So I've already been receiving registrations. I'm open to taking them now, but I just wanted to sensitize you that this would be a webinar that could be for a broader audience. And also at the end, you're going to be advised to complete the survey. We have mentioned this over and over again. It's extremely essential that our funders have an idea of how many attended and what their feelings were about the product that we produced. And sometimes we don't have time to do it immediately and you don't catch the link on the chat box. But when we send the link for the recording, so that you can view it in about 10 days. You will see there's a survey link. Please take the time to complete that. Now, without too much further ado, I'd like to thank our funders, the Secrétariat aux relations avec les Québécois d'expression anglaise, for funding these webinars, and also to acknowledge our partner who has supported us with this project, Québécois. So without further ado, we will have the first presenter. There will be questions and answers. Once again, I really encourage you to put them in the chat box in advance as you think of them. So that way, when Katia is ready to present the questions to the presenter, she has them lined up and we can avoid duplication and we can be ready to roll. And then after the questions to Marlo, we will have a health break for about 5-10 minutes to stretch, get a cup of tea, coffee, and then we'll be coming back and introducing our next presenter, Maître Michael Bergman. So without further ado, I want to start by introducing Marlo. And many of you probably know Marlo. She's got 20 years of experience in management, governance, in nonprofit sector, working with diverse teams to deliver programs related to health and social services, housing, legal services, and many more. She was also the former executive director of Head and Hands, marvelous youth organization based in NGG. And those of us who've been around a little while certainly know of Head and Hands. Marlo understands the challenges and opportunities that come with leadership and also facing the pressing community needs. Her experience is cultivated as a board member at COCO, Center for Community Organizations, and through the Executive Leadership d'Assemblée training program with Centre de Grand Montréal, has given her invaluable tools and knowledge to build her clients' organizational capacity. Marlo is a part of a team that created and taught the certificate program for NDP, which is nonprofit organizations, leadership at John Abbott College. Marlo leads engagements in strategic planning, leadership coaching, governance, funding, diversity, equity and inclusion, as well as design and facilitation of collective processes. When she is not consulting with nonprofits, cooperatives, foundations, and the public sector teams, she volunteers with community-based social justice organizations, including the Réseau de Rushda and the Unitarian Church of Montreal. Marlo founded Social Impact Consulting in 2015 and has worked with over 150 organizations on a range of projects since then. She enjoys spending time in nature if she ever has any free time, gardening and exploring the city, and participating in community events with her partner and son. Marlo, I know you're very busy. I thank you so very much for doing this for us and giving us your time, your expertise. And I'm going to turn it over immediately to you. Thank you.
Thank you so much, Ruth. I just want to check my volume levels. Is this okay for everyone? Looking good? Okay, great. Well, thank you so much, Ruth, Brendan, and the whole team at Seniors Action Quebec for inviting me to this webinar. It's a really important subject that actually affects everyone in the province, and it has a big impact on nonprofit organizations, and I'm going to explain why. So I'm just going to pull up my slides here, and we'll walk you through what Law 25 is. So a little bit, Ruth already introduced me, so I won't repeat that. I do want to acknowledge that I'm working on the unceded lands of the Kanien'kehá:ka Nation, part of the Haudenosaunee Confederacy, and I am really proud as a consultant to have worked with a number of Indigenous organizations in and around Tiohtià:ke, Montreal. I also want to give a disclaimer that unlike Maître Bergman, I am not a lawyer, so I do not give out legal advice. We give out information based on our understanding of Law 25, informed by reputable and legitimate sources of information that we've compiled. And we are not to be held liable for any errors or omissions on the part of a third-party organization, company, or institution. So my team is small and mighty. All of the team members at Social Impact Consulting have been former executive directors in the sector or senior leaders. We also have Sheena and Robert. Sheena is our frontline marketing person, and Robert is our finance coordinator and also my partner. So why did Law 25 come into effect? So this is not coming out of nowhere. It's definitely building on existing privacy laws in Canada. And you may have heard about this little data breach problem that happened based out of Quebec with Desjardins that happened to affect 9.7 million people. It was one of the biggest data breaches in Canadian history. So that definitely got people's hackles up. And there's also been increased consumer pressure and advocacy groups fighting for better protection of personal data. We also know that there's been increased incidents of cyber attacks and scams that can compromise personal data in all sectors. And I'm sure that some of you have experienced some of those scams before, either by phone or by email, people phishing and trying to get your personal information. So everyone should be aware of those risks, and I'm sure that Ruth can point you towards other consumer-based resources so that you can decrease the risk of being defrauded. So why is Law 25 important to nonprofits? First off, I want to let you know that we do have a toolkit that we're going to talk about at the end of this process, because it will feel a little bit overwhelming as I walk you through it. That's normal. When I first faced this as a small business, I also thought, what the heck? How are we supposed to come up with the time, the expertise, and the resources to do this? So we've got your back, and I'll tell you more about that at the end. So undoubtedly, your organization is collecting sensitive data. So for example, maybe you run drop-in activities and you take down people's names and phone numbers. Maybe you're collecting donations through your website. It's possible also that you have people who sign up for an event and leave their contact information. So this is happening across all organizations. Most likely, your digital infrastructure is at risk for data leaks and cyber attacks. No shade. We all struggle with IT things, with information technology, and it can be really difficult to know how to build up safeguards and firewalls and things like that. And unfortunately, a lot of nonprofits are sitting ducks in this area. Another really important reason why it's important to be compliant is that you could be fined, and not small fines. Like the types of fines that we're looking at here potentially can put an organization completely out of business. They are huge fines, and it's very alarming that nonprofits are actually being fined at the same level as large corporations. Don't get me started on that. But all it could take is one, ill-intentioned individual who's disgruntled and decides to call in and make a complaint that maybe is valid. Maybe you have mismanaged their data, or maybe you sent them information without getting their consent, and then you get investigated, and the next thing you know, you've got a fine. So why is this important to you? Probably you don't have a full-time IT person. You may have someone on contract who's been helping you, but we did an estimate that to build everything that you need from scratch in order to be compliant in your nonprofit would take at least 25 hours of labor. So that's, for some teams, that's the equivalent of a full week of work for a part-time or almost full-time employee. So we know that you'd rather be putting that time and money into your mission. Another challenge is that some of the information you've been gathering might be scattered across the organization. It's not centralized. How many of you, just hands, or you can raise your digital hand, have a CRM in place, a client relationship management tool in place? Not a lot. Let me just take a look at the screen. No, exactly. Okay. So client relationship management tools are excellent for many reasons. If you don't have one, you might want to look into it. And Centraide, by the way, Centraide of Greater Montreal does have some funding available to help you purchase and select a CRM. And because you don't have a CRM, your data is probably even more likely to be compromised. It's scattered. Also, another kind of tricky part of this compliance process is that you need to get informed consent from some people. So for example, you've probably filled out those forms that says, yes, I consent to receive the newsletter of this organization. Well, for some people that can be difficult to navigate. Maybe they don't understand what that means. Maybe they have cognitive challenges. Maybe they're having mental health challenges. So actually getting informed consent can be really tricky and can take extra time. So these are some reasons why it's challenging for nonprofits to become compliant. So now we're going to walk you through sort of what are the main components of Law 25? What is the government expecting organizations to have in place, and companies and institutions? So one of the first things that we're going to recommend in our toolkit is that you have a planning meeting. So this doesn't just fall on the executive director or on the board president to manage. This is an all hands on deck situation where everyone has to be aware and following the new compliance measures, and be communicative around these things. So in our toolkit, we do have a sample agenda of what you can bring to your team if you want to start to map this out. And we also have a document that is like a checklist of all the different templates that you're going to need for Law 25. The forms, the reports, the statements, the policies, everything like that. So you can show up at your team meeting and say, okay, team, we have to do this. Here's the list of things we need to put in place. One of the first steps that you're going to have to do is an impact assessment. And this is almost like a risk analysis. So you're going to look at all of the different touch points where you gather data and where you store data, and estimate the level of risk associated with each of those touch points. And you're going to fill out a template, and you're going to create information about how the team stores this information, and what are the individual responsibilities of the team members to keep this information as secure as possible. There's a whole bunch of work around creating documents. And after we went through this as a small business, it occurred to us that, we could just share out what we developed for ourselves with our clients to make their lives easier. So that's what we've done. We've created a whole bunch of different procedures and policies. So one of the first steps is naming a privacy officer. You may have started to see this on different people's websites where, you know, at the bottom of the website or the last one of the pages, they'll say, for more information, contact our privacy officer. Usually it's the executive director or the board president, but it can be someone who's outsourced. It can be like an IT consultant or someone like that. I personally think it looks a lot better if it's the executive director or the board president. I think that's more reassuring for people. And then there's the personal data collection privacy policy. That gets a little bit more granular, so I won't get into that, but that's one of the policies and procedures you need to have in place. There's also the individual data collection report, the breach of confidentiality report. So let's say you accidentally send an email to someone when it was intended for someone else. Who had that here? I've done it. I mean, it's awkward, especially depending on the nature of the email, but there are specific steps that you need to follow, and you need to show in your policy that you do have a procedure in place to follow when that happens. And then you also need to create a data subject access form. And it's one thing that I'm trying to wrap my head around and I'm still getting information on is that they're asking for this to be automated, which means it should be available on your website or on demand by paper where someone can just fill it out. So that will probably look something like a Google form or something to that effect. And that will allow the person to get a report that basically states, here's the information we have on file for you, and here's how we've stored it and secured it. So that's sort of a new right that individuals have, is they can ask any organization for a data subject access form, or just say, what kind of information do you have on me? And you can ask that of your bank, you can ask that of, you know, your tennis club, anywhere where you've given your personal information, you're allowed to ask what they have on you and how they're storing it. As well as the personal data breach complaint form that has to be available on the website or in person. And then you have to log the incidents. You have to keep a record, because if ever you are audited and you're asked about your incident history, you need to have that on hand. And updating your contracts. If you deal with, maybe you're a social enterprise organization and you have the sale of products and services, maybe you bring in contract staff who are also collecting information. You need to make sure that all your contracts are up to date with Law 25. And finally, disseminating the information. There's a statement that you have to include on your website. So we've included a sample statement. You can start to look around at other people's websites as well. Obviously, the statement has to go on any newsletter, survey, or contact form, of, event sign-up page, so that people are aware of the steps that you're taking to keep their data safe. And then just a few more statements. Cybersecurity checklist. This is really important because a lot of nonprofit organizations actually allow their staff to use their personal computers. And sometimes that's because they just can't afford to buy computers, but sometimes it's because the staff person is mobile. Maybe they're running around town. Maybe they're traveling. For some of you out in the regions, you're traveling long distances. So you've got your laptop on you. That's okay, but you have to make sure that you have certain security systems set up. So there's a checklist here that you can go through to make sure that you're compliant. And then you have to do regular audits. So you have to check regularly to make sure everything is functioning. Obviously, it's an opportunity to do some investments in your technology as well, and looking at cybersecurity options for your team. So now on to the goodies. So we do have the toolbox available, the toolkit, and we're offering it on a sliding scale from $250 to $1,500. The costs include all of the templates and forms required, plus an hour of coaching with Sheena, who's helped us develop the toolbox and who's walked at least a dozen organizations through this process. And just a reminder that if you were to tackle this yourself, we estimate about 25 hours of work on your part. If you're using our templates, we're going to save you at least 10 of those hours, at least. You can read more about it on our blog, on our website. I've included some of just a sample checklist at the end of the presentation. So that if you're like, nope, I want to white knuckle this, I want to do this all myself, I don't need your toolkit, that's okay, you can go for it. I've included a partial checklist here. It was impossible to include everything, but at least it'll get you started. And just for you, just today, a 10% discount if you place an order before November 30th. So the link here in blue is a link to the order form. I'll drop it into the chat when I get off of the share screen as well. And don't hesitate to reach out. We do offer on every other nonprofit related subject a free 1-hour consultation. So if you have fundraising needs or governance needs or strategic planning needs or anything like that, don't hesitate to reach out. There's lots of familiar faces in the room. We get to work with an incredible array of leaders and organizations across the province, and we work in French and English. So thank you so much again, Ruth and the team, for having us on. I hope that this helped to demystify Law 25, especially for those nonprofit leaders and volunteers in the room. And I wish you the best in your compliance process.
Wow, we have a lot of work to do. Thank you so very much, Marlo. I've asked people to get their questions into the chat box, so I'm hoping that Katya does have some to start with. Katya, do you have any questions?
Yeah, I sure do. So Marlo, I think I'm just gonna take a step back and try and break down kind of the info that you included. So can you just describe to people who may not know what a CRM is, what exactly it is, and kind of examples of what a CRM is? It like a MailChimp? Is it different software?
Sure. So CRM stands for Client Relationship Management Software. And it's a type of software that you can purchase usually on a monthly basis or an annual basis. The costs vary, but I would say on average, it can be between $30 and $50 a month. And it's a place where you store all of your client data, all of your donor data, all of the points of contact that you have with your participants, your volunteer data. Everything gets stored in this database, and it comes often with its own level of protection. So for example, Donor Perfect is a good example. And they often offer free trials. We do have a list of different CRMs that we can send to people that gives you an idea of what their features are and how much it costs. And the grant that I mentioned from Centred, I'll put the name of it in the chat, but it's called Data Ed. And any kind of technology upgrades that you need, digital infrastructure upgrades in your nonprofit, you can apply to get funding from Centred. Oh, thanks, Mary. I'll change the authorization on the form after. But you can apply to Centred to get funding to help research and acquire a CRM.
Okay, so concretely, let's say an organization has, let's say for their newsletters, they use MailChimp or Nation Builder or another thing like that. Could they use those types of softwares in theory to sort of create the beginning of a CRM, or do they need to get into something else and then just kind of streamline everything just from a logistics point of view? I know there's a lot of organizations here, so that's why I'm just trying to ask these questions.
No, it's a great question. I mean, I'm not a communications expert. Like, there's definitely someone on my team who's a little more familiar with this, Sheena, as a matter of fact. But MailChimp is one tool that it's not a full CRM because it doesn't include all the features of a CRM. It's more like a new mailing list service, right? Like where you can maintain your newsletters, create newsletters, and send them out. CRMs are not mandatory for organizations. I don't want people to think they have to run out and buy one right away to be compliant with Law 25. Most of you are probably collecting data, in Excel or maybe even on paper in some cases. That's okay. You do you, whatever works, right? As long as you keep it secure and as long as you let your general public know through the new forms and procedures how you're storing their data and how you're collecting it.
Okay, perfect. So that was my next question. So, because I'm looking at this from action point of view.
Yeah.
So, organizations don't need a CRM per se. They can still organize or work towards getting one, but they can organize their internal processes if they are more Excel documents and what have you. But as long as the data is stored securely on, let's say, a cloud service or something like that internally, organizations are good to go.
Right, exactly.
Okay.
The one of the benefits of having a CRM in terms of Law 25 compliance is that, as I mentioned, that it'll often come with its own level of firewall protection and security. So it's just adds that extra element of security and reduces the likelihood of data breaches.
Okay, perfect. But step one, they can do that, and then an organization could do an internal audit, figure out the weaknesses, and then put things in place to move towards a CRM.
Yeah, exactly.
Perfect. Okay, now my second question is, I'm going to go back to newsletters. So if you have to ask consent from people that you can keep them on a newsletter list or what have you. So what does an organization have to do? And then to get that consent from people on their newsletter? And is there anything that maybe people on a newsletter list should be aware of or should be communicating with people to say, hey, can you remove me from the mailing list? Can you keep me on the mailing list? So what's like the middle way for people?
Sure. Again, like Sheena would be able to really walk you through this, but I can give you the quick and dirty answer.
Go for it.
So basically, if you already have a mailing list, it would be really good for you, once you've walked through some of these Law 25 steps, to send out an email explaining to your members and participants and volunteers and stakeholders what kind of data that you've been collecting, and give them an opt-out option, right? So send them an email where they can click, or a form is better for your management purposes, that they can click, no, I do not want to receive your newsletter. No, I do not want to be solicited for donations. No, I do not want to receive event invitations, that kind of thing. So they can opt in and opt out. And then you have to keep that organized, right? Because once people let you know their preferences, you've got to create your different lists and make sure that you respect that. And it's good practice to do that once a year, and to also include it as an automatic part of your intake forms, right? Like you're doing intake in different ways across your organization, whether it's for volunteers, staff, or participants. So make sure to include your opt-out clause in those contexts as well.
Okay, and then a question came in about when do nonprofits have to have all of these steps implemented? Because it sounds very overwhelming. So it's just to give people the heads up of when this has to be done by, is if there's a fixed deadline.
Okay, so this is where it gets tricky because they've been rolling out different parts of this, but nonprofits should be compliant now. Like this is something that's been talked about for over a year. There are different stages. There could be other rollouts that are coming, but it's really important that you get on this if you haven't made any movement on it.
Okay, and I think for now, those are the only questions. Like I'm seeing a lot of people are asking questions about, how about Airtable? is Airtable a good system? Is it still, all the different ways that people use for people to register for events? There's a lot of kind of things like that floating around. And
Yeah.
sorry, I got distracted.
Yeah.
But basically,
Yeah, I mean,
it's just that organizations and people who work in organizations just need to start doing the clean, not the cleanup, is need to start looking at things and doing an internal audit and then move things forward that way.
yeah. There's also a question from Doug. How actively is the government pursuing compliance in non-for-profits and applying fines? We don't have any data on that yet. And I have not personally heard of any organization that, that has been fined or that has received any warnings. But I think that's probably because they're just getting their teams in place and they're allowing some people, a bit of a buffer to get compliant. But I wouldn't be too relaxed for too long about this.
Okay. Just another thing to add to the to-do list. Okay. Okay.
I know, right? And that's why we thought a toolkit might be a good option because it'll just cut down the time in half. And we wanted to offer it on a sliding scale so it's affordable. Sorry that the sign up link there isn't working. I'm not sure. I'm having see, we all have our IT moments, right? We all have our IT moments. But I'll send it out with Katja along with the slides, and you can sign up to receive the toolkit
Okay.
after the presentation.
And Marlo, a question came in. Do the forms have to be bilingual for opting out or?
Yes.
Okay.
Absolutely. I mean, that touches on, Bill 101
96.
and Law 96 and all of these other things that we deal with as official language minority communities in Quebec.
All righty. So I think that's it. Thanks so much, Marlo.
Great. Thank you so much. And what is included in the toolkit? You'll see a list when I send it out by Katja, sort of a list of what's included. It's linked in there.
Well, thank you, Katia. Thank you, Marlo, so very much. This was a great deal of information. And I see once again, we got another question about the toolkit by being bilingual. I think now we all realize that working in the province of Quebec, because we just did a training session with Educalois, Katia and myself on Bill 96, things have to be bilingual in Quebec. And you'll notice that even when we advertise our webinars, you're going to see a French version of everything that's transpiring, but we do state that the webinars are in English. So bilingualism is the way to go in the province of Quebec. Marlo, thank you ever so much. This was great. And I know that everybody's going to be wanting to have access to the toolkit. And of course, you have, maybe while I'm talking, you can just put your slide up with your information about your services, and people can quickly read it, maybe grab your website or your phone number. So thank you once again. We are going to go for a brief health break. I'm just checking the time. We are ahead of the game a little bit. So what I can do is say that you've got 10 minutes, but I don't want you to all close down and go off and do other things. We have Maître Michael Bergman, who is the lawyer with Bergman and Associates, and what he's going to be talking about, which is going to be Bill 25, but a different side to Bill 25. It's on your agendas, but I just want to re-emphasize it. The legal protection of our personal, and if you're running a business, that information, but the loopholes to avoid unknowingly disclosing with or without your consent your personal information and your business information on medical, financial, and your personal profile on social media. So that is going to be very pertinent, very informative for all of us, be it you're an employee in a nonprofit, you're running a nonprofit, you're running a small business, or us, like me, a senior. So take your 10-minute break. And do come back, and we'll start back and introduce Michael properly. Marlo, thank you, thank you, thank you. And you're more than welcome to stay if you want.
Sure, thanks.
Well, welcome back, everyone. Thank you so very much for staying with us. I hope you were able to stretch your legs a little bit. And now we're going to go into our second portion of our Bill 25, Protecting Our Personal Information webinar. And delighted to have a longtime friend and colleague, Michael Bergman, who is a lawyer and the founder and principal of Bergman and Associates. And it's been, Michael, 47 years you've been in law practice, and you've pleaded before the trial and appellate courts of Quebec, Ontario, Nova Scotia, Alberta, and the trial and appellate federal courts, the Supreme Court of Canada, the United States District Court, and diverse administrative bodies. I'm exhausted already. Maître Bergman has represented clients and made presentations before committees of the House of Commons, Senate of Canada, and the National Assembly of Quebec. Maître Bergman is a member of the Quebec Bar, the Ontario Bar, the Canadian Bar Association, and the Association of Trial Lawyers of America. He served as a member of the board of directors of the Bar of Montreal for 3 years and was also its treasurer. He is also a member of the executive of the Canadian Jewish Congress, Quebec region, and a long-serving member of the Lord Reading Law Society Board of Directors. Michael presently lectures on constitutional law and language rights at the McGill University Faculty of Law and frequently provides legal training to lawyers. He's also a frequent speaker on diverse topics in various forums and has spoken extensively regarding Bill 96. He is also the founder of the Legal Information Clinic of McGill. Michael, I know you from back, I guess, in the 80s at Alliance Quebec days, and I know your expertise. I'm delighted that you're able to give us this time. And we look forward to how you're going to inform us, educate us on Bill 25 this morning. So thank you so very much.
Thank you. And although I'm very delighted to address the audience, I'm even more delighted to speak to Ruth. It's been many, many, many years. We go back, and I want you to know, Ruth, you still look the same. And that's not an exaggeration either. She was, Ruth, an important part of Alliance Quebec and the English language rights protection of the community. So I'm delighted to speak to Ruth and to the audience. Law 25. This is a legislator's, Quebec politicians' delight. This is what the law, the National Assembly adopts when they have not much more to do. And why is that? Laws are meant to protect people, to create frameworks and structures by which our society is governed and operates. Law 25 will protect the people who don't need protecting, because all of you are law-abiding citizens. Your organizations, your not-for-profits, are law-abiding citizens. The problem that Law 25 ineptly tries to address legally is the problem of technology, and specifically computer technology, and more specifically, the internet, which is pervasive, everywhere, everything, all of life seemingly is on the internet through the computer. And the people who would use steal your private information, they're not law-abiding citizens. They don't care about Law 25. And so they're unregulated and unbound. And of course, hackers, computer hackers, are notoriously difficult to find, let alone prosecute. So Law 25 is trying to organize your life to meet the problem of illegal activity. And because technology changes every day, every week, every month, you're always running to play catch up. No matter what tools you use to protect private information or to protect how you give private information, the hackers and the criminals are always one step ahead because technology changes and the systems put in place, even the well-crafted report and presentation by Marlo, you can't update it every day because the resources available to do that every single day are just not there, and it's extremely costly. So what does Bill 25 do in law that affects you? Bill 25 tries to basically regulate how you give private information and how the recipient receives it, what they do to store it, how you can retrieve it, and how it can be used. Basically, 4 things. And of course, generally, most people are giving private information today through the internet. Some people still give it by paper, some by telephone, some in person when you visit a doctor or even a lawyer or whoever, but usually it's through the internet. So Law 25 makes it a requirement that everybody who receives private information, without distinction, as Marlo says, must have an appropriate system to manage the information, to keep it, to store it, and to protect it. If they don't, if the recipient doesn't, they may be liable to significant fines and going as far as $25 million. Oops. Even if you won the lotto, you're unlikely to be able to pay that fine. You need to make sure that your planning is up to date and you are subject to the surveillance of a government commission. That probably is the easiest part of the whole thing, even though it's time-consuming, costly for big and small businesses and for not-for-profits. Certainly, it is, in my view, unlikely that a not-for-profit can run fast enough to keep up with Law 25 unless you're maybe Centraide. So let me start with the individual, which is probably what's of most interest to many in the audience. You probably give every day to somebody private information, your name, your phone number, your address, your email address. Maybe you go beyond that, your health, how you're feeling emotionally or physically, your finances. Different people for different legitimate reasons want to know how much money you have. What are your resources? Your social information, your family, your friends, your immediate circle. To give that information, other than in a pure family or friendly setting, the recipient needs to have a mechanism to protect it. But to protect it also means getting and obtaining from you your informed consent to give the information. So if your local supermarket says we need your coordinates, as in your name, address, phone number, whatever, we need to know times when you're available in your residence for delivery. That is private information. In giving it, you will really have no choice, otherwise you're not going to get the delivery. But the supermarket needs to say, look, we need this information, it's private. Do you agree to give it to us? Do you want us to know this? Because we're not just writing it down on a napkin, so to speak. We're going to enter it into our system. So in the future, it makes it easier for us, the supermarket, to retrieve it and to use it. Now, what does the supermarket do with that information? First, it has to record that you've consented to its use. The second thing, they need to keep it. They can't disseminate it. They can't sell it. They can't give it to an aggregator. In other words, a business that aggregates this information in order to give you indirectly some kind of other marketing pitch by somebody else. You have the ability to call the supermarket and say, you know what, I no longer want you to have this information, so delete it. And so the supermarket has to delete it from their system. They need to confirm to you that they've deleted it. Now, let's say they don't do that. They disseminate your address, your phone number, and your email address. And somehow you find out about it. You can complain to the commission that's been set up by the government, and the commission will make an inquiry, and the commission may fine the supermarket. This is a very simplistic view of how this system works. The problem is, of course, how will you ever know if the supermarket actually disseminated your information? Very hard to know. And if you want to order and have your shopping, your food delivery, you need to give this basic information. So it's like a vicious circle. They need the information so you don't have to go down to the supermarket, particularly as one ages. Maybe you want to use this kind of service, but all kinds of people would want to use it. I know in Manhattan and New York City, it's very common that people no longer go to supermarkets, they just order online and they get the delivery. And of course, you can order online or you can order by telephone. So the same problem in a very simplistic environment reoccurs over and over again. And you could say, well, they'll be fined 25 million. I don't think it would be 25 million unless it's the most egregious case. But how will the system really function to protect you? And then you get the problem of information sought by vulnerable people. There is no shortage today of scammers. People who do telephone calls, they send you text messages, they send you emails, and some people do fall for it, including, by the way, people of all educational levels, people of all age categories. It's not just the senior citizens. There's a hell of a lot of people that fall for this stuff. that this law is not going to do anything because those people, they're in another country. So they're not going to get caught, which raises another problem. A business, a legitimate, lawful business in another province or another country that has a website, you want to place an order. Whether or not they're subject to Quebec law is a very open question. And that poses two elements. Number one, usually most websites, the first thing that pops up are the questions about cookies. I don't know where the idea of the word cookies comes from. Sometimes I wonder why they don't call them biscuits or cookies and biscuits or cake or pie. Cookies. And you see, you have a choice. You have a choice of accept or decline. Sometimes, not all the times does it say decline, or look at other options. Under the Quebec law, Law 25, you have a right up front to decline. But many websites that are not in Quebec don't offer you that option. So you're quite often stuck with the cookie. What is the cookie, right? By the way, I love Dare chocolate fudge cookies. Unfortunately, no website that I've gone on seems to deliver me Dare chocolate fudge cookies. The cookie is really a misnomer. The cookie is a technological, automatic, computerized function that collects information. Because the internet in its different forms is really functioning by an algorithm that is constantly searching for information about how you use the internet. So it can redirect you to businesses that may be interested in your profile. This is what Google is about. This is the secret to the multi-billion-dollar success of Google. You don't know that, but your information, Michael Bergman, Ruth Peltier, Marlo, whoever, is out there on the internet in this Google system. Law 25 does nothing about it because it can do nothing about it. So when you go on the internet, if you want to buy something, take something, get information, you are more and more vulnerable. But even watching the internet plays into the algorithm because the algorithm is monitoring how you entered the internet and what you're looking at. Let's get more particular about this. Let's get to medical files. It's been a long time that medical files by your doctor, your medical clinic, your hospital cannot be released to anybody without your written consent. This was true when your medical information was basically on paper. And it's equally true now that most medical information is digital. And in case you're not aware, all of your clinical information, your doctor's notes, your laboratory tests, they're accessible online on a supposedly secure website by Santé Quebec or whichever other annual nabob is in charge of this stuff. Now, you can retrieve your own information by giving your consent. The problem with this, which is exacerbated by Law 25, is what happens when you need to disclose to others your medical information, but you're not in a position to do so because you're lying in a hospital bed and you need your children or your spouse or somebody to get it. They can't get at it And technically, the doctor, the hospital clinic can't disclose it. So now people who are important to you, who are taking care and concern about your health, can't see the problem. That's why everyone should have what's called in Quebec a mandate in the event of incapacity, so that when you are incapacitated, they can access that information. Worse is when you have a death in the family and you want to see the hospital record. What went wrong? What's going on? What happened? The law says you cannot see it, except on two situations. One is if you are the liquidator of the estate. And the other is if you can prove that having the information, I've never seen this in the law, if you can prove that having the information will assist you in grieving the death of your loved one. How exactly are you supposed to prove that you will be assisted in grieving the death of a loved one? Do you need a psychiatrist or a psychologist report? Who knows? Another problem which many parents complain about is you can't necessarily get access to the information on your children. Your adult children, certainly not. Your minor children under 18 years of age, well, if a child is 14 years or older, that child can access their own information. And the child can block you from getting that information also. Another thing, you could give the hospital, for example, a letter saying, I do not want my information to be disclosed to anybody. In light of that letter, you cannot seek out that information without a court order. So life, you may be protected, but life for those who need the information, properly speaking, just became more difficult. The same is true of financial information. Now here's a head scratcher. You can't get a credit card, for example, unless you disclose some information to Visa, MasterCard, American Express, or whatever card it is. But they can't use that information without your consent. They will ask you for your consent, not only for their own records, but of course they want to give it to the credit rating facility. But if you say no, then they can't give it to the credit rating facility. Then your credit rating can't be assessed so that maybe you can get more financial benefits such as loans and whatnot. So suddenly, how you approach disseminating your financial information becomes more difficult. And it's not realistic. What about social media? Everybody that I know and most people know, they're on social media. Myself, not to any serious extent. I have better things to do, like defend people's rights. But in social media, we all say private things about ourselves. Facebook, Instagram, X, which used to be Twitter, whatever. They don't seem to be captured by Law 25. So whatever you write is out there. Period. Another problem that Law 25 cannot deal with. Once you're on the internet, once your name is on the internet, once you've done something that the internet records, you can never delete it. You can never erase it. It's there forever. So this idea of using your consent as a legal tool and withdrawing your consent is somewhat illusory. Because if your information or you have put information on social media, it's always going to be there. Who legally suffers? Every business, every not-for-profit that has to store confidential information also needs to keep records of what they call an incident report, a breach of confidentiality, a hacker, whatever. The example of Desjardins that Marlo gave, which is one of the largest breaches, there have been larger breaches in the United States. Well, that's all well and good. But basically, the business or the not-for-profit that suffered the breach could be sued for not having proper mechanisms to secure private information. Now, maybe they can do the best they can. Maybe they're up to date. Maybe they pay like all law firms that I know of for IT people to monitor the system for breaches and hacks and worms and viruses and all kinds of other nasty things. But at some point, you just can't keep up. If you don't have protection against viruses, if your virus protection system goes down, for example, you're probably going to find that from the beginning of the day to the end of the day, you have been attacked or your system has been attacked by at least 1,000 viruses, if not more, or tens of thousands. So you're exposed as a not-for-profit, as a business, large or small, as a mom and pop dependent, you're exposed to potential liability from this. And that potential liability will come from those of you in the audience who are individuals who say, my information was hacked and breached, but because your system didn't work, wasn't up to snuff. So I'm going to sue you now for $100,000. Never mind also the fines that the commission can impose. But everybody's working hard to keep this up. This is why when I began, I said, this law is for people who observe and abide by the law. It's not about the criminals and the hackers. When the Federal Parliament of Canada introduced legislation not quite as demanding as this 2-3 years ago, and they put in a provision that you could not insist that people constantly subscribe. You had to get permission for repetitive information to be disseminated to people's internet and emails. You had a choice of clicking unsubscribe or subscribe. And this was supposed to be the latest cutting edge idea. It didn't do anything. It just made the people who obey the law work a little harder. The criminals still got away with it. The other problem, of course, with confidential information is who protects your information from use by different departments of the government. Now, the law does say Department A cannot share its information with Department B. But the law can also say something else. It could say, in some cases, Department A shares the information with Department B. I'll give you an example. The electoral list, which is used by the Motor Vehicle Bureau driver's license, it's used by Medicare to keep things up to date. There's no reason why the law, in certain respects, cannot allow different ministries to access Revenue Quebec and your financial information. So there's no end to it. Instead, we have a law. I'm going to show you on the screen. This is Law 96. Now, never mind the front page. It looks like that. Look at how thick it is. See how thick that is? Right. So that covers much of what I'm saying, but it changes very little. Of course, we're Quebec. So everything's got to be in French unless there's a valid exception. If you're not a historic Anglophone, you need to give your confidential information in French. Who is an historic Anglophone? I mean, I don't know about you, but I feel quite often very historic myself. I didn't feel that historic when I was much younger, but, you know, especially since I went bald, I think there's a lot of history that reflects off the top of my bald pate. It's somebody who went to English language primary, or what used to be called elementary, or secondary, what used to be called high school in English in Canada. If you didn't go to high school or elementary school in English in Canada, then you're not an historic person. And therefore, you can only communicate in French. Now, of course, the government asks you, you know, this kind of idiotic thing, do you promise to click the right button and tell the truth that you're really historic? Well, if you're very honest, you're probably going to say, well, I can't click the button. If you're less than honest, and I don't want to call anybody here dishonest, you'll click the other button and nobody's going to know, but that still legally creates liability. The next problem, of course, is how is your confidential information stored? Is it stored in English or is it stored in French? And that's not obvious from the law. So, what good is this law? This law is about trying to scramble to keep up with computer and related technology. This law is already out of date, but the costs to not-for-profits and mom-and-pop businesses and businesses large or small, as Marlo just said, are enormous. And most businesses and not-for-profits are scrambling to just keep up. In fact, I dare say that most people haven't even heard of the law. They don't even know what they're supposed to do, that they should be doing something. If you're an individual, protecting your private information legally begins by being smart about it. Disclose your information only to people or to businesses or websites that you trust. And being skeptical is a watchword. Otherwise, all of these complex systems are not going to fundamentally protect you, but they are certainly one grand and great make-work project for those of us who abide by the law and provide services. I'm open to questions and answers, or your answers and questions, and I'll be happy to hear you.
Michael, thank you so very much. I think we're all, well, I'm certainly guilty of providing information to many different websites and organizations, etc. And they have tried to hack me a few times, so I'm sure everybody can relate to what you've been telling us. And I see that there are questions in the chat box. So Katya, I'm going to turn it over to you so you can ask the questions to Michael, and then I'll come back and do a wrap up.
Okay, thanks, Ruth. Okay, Mr. Bergman, I hope I can ask you coherent questions because I'm not gonna lie, my head is spinning a little bit. Both as a civilian and as an executive director of an organization. So the first question that came in, and I think it's the best way to start, is Bill 25 a provincial law, or do other provinces have a similar law?
Okay, so before we start with the answer,
Yes.
let's start by getting mixed up.
Okay.
Bill 25, when it was a bill before the National Assembly, was called Bill 64. When it was adopted, it turned into Law 25. So sometimes when you're trying to look on the internet for the law, if you're interested to read it, but why you'd be interested to read this law? Unless you have insomnia is beyond me. If you look for Bill 25, you may not find it. You may have to say Bill 64. Okay. Other provinces have, some provinces have a law like this. The federal parliament has a law like this. They're not identical. The problem with these laws is, how do they cross borders? Does Law 25 apply if you're in a website in Ontario or in the United States, or a website, let's say, in Bermuda or the Cayman Islands? That's a big open question. So yes, there are other places with laws that try to deal with this. These laws all face a lot of the similar issues, but Quebec's is unique amongst all these laws because Quebec deals with cookies. And Quebec says you need to, before entering the site, have a means to say that you decline all cookies. Whereas in the United States, the other provinces, the federal authorities, we don't have that. But I tried to deal with what is a cookie? A cookie is the computer technology embedding in your computer a way of understanding your likes and preferences. So right away, when you click yes for the cookie, you're basically giving out confidential information. But there doesn't seem to be much you can do about it. On the other hand, there are many websites outside Quebec where there's no decline button because they don't feel they're bound by Law 25.
So it's the cookie element that is the unique characteristic of Bill 25 in Quebec.
That's one of them, but that's the one that troubles businesses the most.
Okay. My next question is, when you were talking about the medical files, Mr. Bergman, I just wanted to circle back to that. So you were saying if someone is incapacitated or hospitalized, family members cannot access medical files of said patient.
That is absolutely correct.
Okay.
And the doctor is, unless the doctor is, shall we say, whispering very quietly, cannot disclose it either.
So then in a medical emergency, pardon me, how can family or anyone else get access to a medical file of a loved one?
It's very difficult unless the doctor, because of the nature of the emergency, needs information that is not otherwise available. So most doctors are going to give the family just a general framework of what's going on, but not any real detail. The only way that you can secure the details is if you have a mandate in the event of incapacity, which appoints you as a mandatory, meaning an agent or representative, and then you can get the information.
So,
Or if the patient family member is still able to express themselves and test the doctor, give my son the information.
okay, so you need the consent through a legal document through a mandate.
Ideally, yes.
Okay, now, does the same rule apply if family members live in other provinces or abroad, or is it even more complicated?
The same rule applies across the board if the patient is in Quebec.
Okay. My next question is, I'm just gonna go up here. I'm trying to make sense of this. Okay. Can a standard errors and omissions insurance for administrators and directors help to cover potential risks of an organization being sued privately?
I think that you would need to ask your insurance company or your insurance broker if your not-for-profit is covered or your business is covered for this problem.
Okay, perfect. So for organizations moving forward, they can check in their cybersecurity or in their board insurance.
You sit down with your insurance broker or insurance agent, you need to say, hey, let's review together the information, the insurance that I need. And does it include cyber breaches?
Mhm.
Confidentiality incidents. And your broker's probably going to say, well, it could with an endorsement, but that's going to cost you extra money. And then the broker may say, what have you put in place the systems? We have minimum standards. You need to show us that you have adequate systems to prevent confidentiality incidents.
Okay, I'm not sure if you'll be able to answer this one, but another question came in and it was about the non-compliance of an organization. So let's say, so how could someone know if a hack, for example, was a result of an organization or an enterprise or what have you, not being compliant to Bill 25?
If you can demonstrate that you have assigned a person in charge of confidential information, that you've created the systems the law requires or the government regulations require, then even though you're totally innocent of the hack, you will have a problem. Because you have a duty in the law now to protect this information. And the way you perform that duty is by having these systems that the law requires in place.
So you're kind of saying, you're mirroring what Marlo said in her presentation, that for organizations to have systems such as CRMs and all that, you really need to do an internal audit and see how everything's
Absolutely, otherwise you're exposed.
exactly. So
You have no proof that you've done what you reasonably could to comply.
got it. Okay. I don't think there's any other questions. I'm trying to think of some off the top of my head, to be honest, but my head is spinning, Mr. Bergman, because it is a lot of
Yeah, there is one from Agape on there.
Oh, go for it, Ruth, if you want to ask it.
I'm having trouble with my mouse to scroll. Andrew
Okay.
put it in. It's to do with
Oh.
financial.
Is it the international one, Ruth? So there was a question that came in, Mr. Bergman, about, I know we talked about provincial provinces in Canada, but a question did come in about, are there any international laws that are similar to Bill 25 that can to protect private information?
You mean international bodies that have imposed standards? Yes, but
Okay.
they're not enforceable, basically.
Okay.
There's no Interpol that's going to police this. And the problem, of course, of many of these websites is they're not located within Quebec or within Canada. It raises issues about can you do anything locally, let's say in California? Well, you're not going to run to California, most people, to launch a lawsuit.
So there's a bit of a cheeky question, and I'll ask it. So someone asked, so what are the advantages to having a Bill 25 or a Law 25?
When you have a fire in a building, unfortunately, the building burns down and there's injuries, and unfortunately there's death. The politicians all run to say, we've got to stop this. We're going to do something. We're going to pass a law. So they pass a law. The problem is, next time when a building burns down, you still have a burnt down building. Now, maybe there are smoke detectors and other safety systems, but you still have a burnt down building. You're trying to put your finger in the dike to prevent a leak. And I'm not saying the law is totally useless. I'm not saying the internet shouldn't be, in some respects, regulated. But this is not going to be an effective way, in my view, and you may have others who say differently, to do that. Yes, companies and people who store information and governments have a responsibility. And that responsibility in the law should be clear, what standard they need to meet. But that by itself is not going to prevent hackers from getting the information. And hackers hack the Pentagon. You know, how more secure can you be than the Pentagon?
Okay, so Mr. Bergman, 2 more questions came in, and a community group asked, is it a good idea for lawyers to draw up policies on the implementation of Law 25 for an organization? Or can someone else do it?
The answer is, if you're asking about the legal process, the legal construct, framework, structure, the legal liabilities, the legal consequences, then yes. If you're asking a lawyer to speak about the technology, no, because lawyers generally are not, not computer wizards. I often describe myself, even in court to judges, as a techno chump. That's a bit of an exaggeration, actually, but yes, if it's about the legal aspects, the answer is yes. Should, for example, not-for-profits band together so they each don't have to run and spend money on lawyers and get one lawyer to do this and share it together? That might be a good idea. And at least you have a legal opinion as to your attempt to comply if something goes wrong.
To work together. Understood. Okay. I don't think there's any other questions, Mr. Bergman, so thank you very much.
Thank you.
Katya, I see where someone has asked, if a person discovers that a company had a breach of confidential information other than the company's investigation, where do we go next? She's worried about
You go to the
identity theft.
commission. You can file a complaint with the commission.
Perfect. Michael, thank you ever so much. I think our heads are all spinning because we have all the aspect to the technical aspect from Marlo and implications, and then Michael has given us the legal implications. So I think it's something that we have to take back. We have to discuss with our boards and our staff. And like Michael had a good suggestion, maybe pool our organizations together and get the professional expertise that we need. And I know Marlo has been answering a lot of questions on the chat line for organizations who wanted to look into her services further. Brendan has just put the link in the chat box for the survey. So if those of you who are computer competent to take it and fill it out now, that would be great. It's on today's session. Those who prefer to do it when we send you the link of the recording in approximately 10 days, fill it out then and please send it back because it's essential. And Marlo, Michael, thank you ever so much for all the people who are online and stuck it out. I thank you very much. It was nice to see so many new faces. And if I might take a personal minute to say hi to Brendan, who knows me from the late 60s. So welcome aboard, and hopefully we'll see you in future webinars. And this has been great. So I managed to finish a little bit early. So go and enjoy your day.
Thank you. And if anybody has questions, they're free to call me or email me if you like.
Okay, so I can provide that information. If it's somebody who's on the line now, you can contact me and then I will send you Michael's coordinates rather than just spread it out to the world. We're going to start exercising caution.
We have official consent, Ruth.
No, my coordinates are not confidential information. As I say to everybody when I give out my cell phone number, go ahead, call me day, night, weekend. Don't be shy. Nobody else is.
Okay, so I'll thank you all and bid you a good day. And don't forget December 10th is the next one.
Thanks.
Thanks.
Thanks, Ruth. Thanks for organizing it.